Honourable Deputy Speaker, මට පෙර කතා කරපු මන්ත්‍රතුමාගේ කතාවේ අන්තිම කොටසේ බලලා මල්ලෙන් එළියට පැනනා වගේ තමයි කතා කරේ. ඇත්තටම මේකේ ආණ්ඩුවේ උමනාව දේශපාලන දැඩි මතධාරී අදහස් දරන අය මේ පුනරුත්ථාපන කළ යුතුයි කියන චේතනාවක් තියෙන බවයි අපිට පෙනී යන්නේ. ඒක තමයි මේකේ තියෙන වැදගත්ම කාරණාව. දැන් මේ පිළිබඳව මීට කලින් කතා කරපු මන්ත්‍රතුමිය ඇතුළුව කීප දෙනෙක් විශේෂයෙන්ම මේ ශ්‍රේෂ්ඨාධිකරණයේ තීන්දුව පිළිබඳව සඳහන් කරා. සම්පූර්ණ පනත කෙටුම්පත ව්‍යවස්ථා විරෝධී එකක් හැටියට හඳුන්වා දෙමින් ලබා දුන්නු තීරණය ඊටාම මීට පෙර කිසි විටක සිදු නොවූ නැත්නම් ඊටාම අල්ප වශයෙන් තමයි එවැනි දෙයක් සිදු වෙන්නේ. If I am to say this, in the recent history of this country, it has never been possible for the Supreme Court to say the entire bill violates the Constitution. So it was drafted in such a way, totally contrary to the purposes even of the cabinet memorandum. Somebody in the defense ministry thought that we must include certain provisions so that we can bring in several categories of people who will be who have been identified through a vague interpretation of the law, so that they can be sent to rehabilitation centers to be set up. Now this is the whole problem. Now if I am to tell you this, Mr. Deputy Speaker, globally, including Sri Lanka, the approach towards compulsory rehabilitation is counterproductive when it comes to drug rehabilitation, because it leads to relapse. You have these withdrawal symptoms of these drug-dependent person. So it can lead to relapse and various other problems. So this has to be done through a proper medically qualified personnel who will run such centers. You don't involve the military in rehabilitation centers of this nature to rehabilitate drug-dependent persons. This is why I mentioned in the consultative committee that this bill must be examined by the committee, taking time, so that we should not rush into this. But then there seems to be some haste by the government to try and set these centers up for some other reasons. Now they earlier had these categories called ex-combatants, violent and extremist groups, and other groups of persons. That was all struck down by the Supreme Court judgment. So they have had to remove that. So now they have now stuck to this drug dependency issue. Now substance abuse in this country is a rampant problem, we agree. Now it has to be a curative process, not a punitive process. You don't compulsorily send people into rehabilitation centers. When you make it a compulsory rehabilitation, what happens in this Kandakadu and the Senapura centers? How many times have people broken away and run out? Right? Because of torture that takes place there, hard labor that they are subjected to. The military personnel who are running those centers have been found to be so insensitive sometimes, treating those inmates with such gay abandon, using so many other punitive measures. So this has to be regulated. So do not think that by setting up such centers, you will finally we will become a banana republic which is setting up detention centers to send ordinary people, because you will find ways and means. Now you see, you are identifying a group called other persons identified by law. Now there is a serious suspicion that subsequently government can bring a law to identify this other person's group, and then to send them also for rehabilitation. The other person's group is a very vaguely worded group, which is an unidentified category. Now there is nothing preventing the government from passing later legislation to try and identify such other persons. Now we must understand that, since I have already mentioned about the military involvement in this thing, then what about the social stigma of persons who are being forcefully sent to these centers? No, this has to be totally voluntary issue, and then you enter in these centers and coming out needs to be a voluntary issue. You can't forcefully keep people without proper judicial supervision setting up such centers is very harmful to society's, the harmonious society. And this is what we are saying. Of course, substance abuse is a problem in the society, but then we need to follow the international best practices. What is the international best practice? The UN has been very, very clear on this. They don't encourage such practices. They rather see that these centers are set up by properly qualified psychologists and medically qualified people. But you don't allow the army and the armed forces to run such centers. And this is a very, very, if you look at what has happened in Senapura and Kandakadu camps, in last several years, this has been the frequent occurrence. Severe violence in those camps have been reported. Serious human rights violations have been taking place inside those camps. So now you are trying to hide behind the hype that have been created by the media about drug-related issues and then overcrowding in prisons. Then this is not a solution for overcrowding in prisons. So if you are going to do that, but then this bill has to go through radical changes, in my opinion. So those radical changes were never discussed, and there was no sufficient time provided for the opposition to discuss the serious gaps that we find in this bill. This is why we are opposed to this. And then we also have, now of course there is a provision for the magistrate to visit the centers every month. So monthly visits, now there are officials at the table who have been in the judiciary also know that it is practically impossible. I don't think magistrates, even in other, there are provisions in other laws also for magistrates to visit prisons. But how many magistrates find the time to go and visit prisons with the caseload they had to manage in the courts? You see? So that will hardly happen. And even if it happens, this is only going to happen once in a month. So in between, the rampant torture that takes place, and also now if you want to complain, then you have to go through a laborious process of making a complaint and IGP to take a decision. Never before have we seen substantial inquiries being conducted and persons being convicted of torture. Now if you find now Convention Against Torture, we are a signatory to the Convention Against Torture, that if you see the amount of convictions is hardly anything that have we achieved in this country. So therefore, this whole thing has been designed with a view. That is why the former member who spoke, Honorable Pascal, finally came out with what was the hidden motive of the government. That he virtually mentioned that some of the political groups are mentally deranged. And, they need to be rehabilitated. And about talking about burning houses. Of course, unfortunate things happened during the civic unrest that we faced between April and July last year. And that was an unprecedented thing that happened because of the government's totally regressive way of addressing the issues in the country. So now, as a means to control such civic disobedience, you don't set up rehabilitation centers, and that is why the Supreme Court gave you that damning indictment by totally throwing out the entire bill, saying it is unconstitutional. So, having now taking the advice given by the Supreme Court, you have only now limited it to the drug-dependent persons. But even then, yes, even then, that is my argument. Even if you do comply with the Supreme Court's order and have now restricted it only to the drug-dependent persons, right? Sending them for compulsory rehabilitation is something that you have to rethink, because that is going to create serious issues in the society, because rampant abuse have been prevalent in such camps. And then we can't become another banana republic which sets up these detention camps like in some of the, one-party countries, single-party rule. And this is what is going to happen. So we cannot, in a law-abiding society, set up such centers without proper regard to the human rights norms in the country. And then the constitutionality of the bill has been totally, bound to be totally unconstitutional. And then now, though you have complied with the advice given by the Supreme Court and limited it to one category of persons, even those category of persons will finally be subjected to very, very inhumane treatment in these centers if you don't follow the international best practices to avoid compulsory rehabilitation and then to have medically qualified personnel, psychologists and others to man such centers. Not to involve the military or armed forces in such matters. Of course, you have provision under the PTA to have a Commissioner General's office for rehabilitation. That did happen in the past, and those camps were set up, and then certain psychologists and other medical advice was also given, and several times, twice during the insurgencies in the past, once in the 70s, in the late 80s, and subsequently after the LTT war was concluded, then again such centers were set up. Thousands of young combatants were rehabilitated. That was a different issue. Don't confuse that with this. What happened last year from April to July was civic disobedience. And you don't consider them all deranged people and want to push them into a rehabilitation center. That was the original motive. That is why you identified those categories as ex-combatants and people entertaining extremist ideas. And now, having been given that thundering slap by the Supreme Court, by saying that this is an overbroad and vague definition, now you have restricted yourself to this category alone. But even then, there is going to be rampant violation of human rights of those inmates. Therefore, we feel that this bill must be reviewed once again. At least I plead with the government, refer it to a standing committee and let us look at it before you put to vote. Because this is a serious violation of the rights of the people. Having said that, I conclude my speech. Thank you.
බොහොම ස්තුතියි ගරු මන්තුමනි ගරු රාජ්‍ය මන්තුමා අනුරාධ ජයරත්න මන්තුමා
Need to clarify two things. First, this act has been taken before a consultative committee twice. For the first one, you've been there in the consultative committee and you all have requested for another time to give your opinion. So that meeting was also taken yesterday. But, Honourable Member, you were not present. So that's, I don't think that's...
Rauff Hakeem මැතිතුමා.
Honourable Minister, your government has called for an election. We are party leaders. Busy
I totally understand. But
right?
What I want to clarify here...
You call for a consultative committee
Deputy Speaker,
in the middle of nominations that we concluded in 2-3 days. And we are filing nominations all over the country. So we are not busy, so how can we attend?
And the Parliament is two different things, Honourable Member. And what I want to clarify here, Honourable Minister of Justice has given the opportunity for you all to submit your opinion, which you have not, you have failed. So that's why I just want to mention here.
What and the second was thing, going to summon a consultative committee. But I say, even now, you don't have to do this in post haste. No, why don't you refer it to the standing committee? Yeah. Right? And then
Honourable Member, and the second thing, what I want to clarify, I won't take much time. On the Supreme Court determination on page 17, B2, it clearly says, the bill is limited to the rehabilitation of drug-dependent person and such other person as may be identified by law. It says any other person, such other person as may be identified by law, not by an individual person, not by police or any other party. So this basically referred to the law. So I don't think there is any problem or any question arise here. As you mentioned, if you have the determination, you can look into that, Honourable Member. That's on the page 17, B subsection 2.
No, let me read this. Now there is about the same thing, the vagueness and lack of clarity in the core provisions, what the Supreme Court says. He says the answer that subsequent specific laws will deal with define the persons who require rehabilitation is a dangerous route for this court to adopt in the specific context of this case. It goes on to say, it's the constitutional duty conferred by Article 123 in examining this bill on the basis that a future law will fill in all the blanks of this bill. Furthermore, in a constitutional framework that does not provide for post-enactment judicial review and only a limited time period for challenge of the bill, there is no guarantee that this court will definitely get the opportunity to consider the constitutionality of such subsequent bills. This is what we fear. You say there are a category of other persons, and then we fear that there will be a subsequent bill. And this is the very reason the Supreme Court has foreseen that you are going to do something like this. That is why they have mentioned this in their judgment. So that is why I am saying, please refer this to a standing committee.